about 2 or 3 problems today. I had to end a little early. I have a meeting. Sorry about that. So we've been moving pretty well through the material. So we're going to sort of review what we did in chapter 11 up to this point, and then move into the problem. I don't think we did finish the Sudan hypothetical. I sort of set it up. There are 5 questions we have to do. And then there's a second part to that. And then there's another case about presenting evidence. So we want to be able to do that. Drawing upon these rules on the board. And so after we come out of the conflict material, now we're looking at our duties to courts. And third parties, we'll see finish the third party. But we started our analysis, starting on page 471 in chapter 11. With sort of theoretical discussion, starting on page 474 about a good lawyer or a bad lawyer. And we noted that procedurally, we're advocates. We press for our client's viewpoint. We try to achieve our client's objectives, and that's fine. And we compared 2 things on page 474 and 475, where we were making formal technical objections under the rules, clearly within the rules, but for different purposes. For one, we were trying to buy a poor client some time. The other, we were trying to advance a wealthier, more sophisticated client's goal by stringing out discovery and motion practice, knowing that the other side didn't have that much money and staying power in the litigation. So will we use formalistic tactics to advance our client's claim? And the rules are designed in such a way so that we won't abuse them, but we certainly can use them to advance our client's claims. And that's what 3.1 is all about. It talks about meritorious claims and contentions, prohibits frivolous claims, and we know what that was. We have to make sure that we do the factual investigation so that we are advancing them. So that doesn't mean winning or losing. That's why I put comment 2 on the board. You see, if you look at comment 2 to 3.1, it says something like this. What is required of the lawyers is that they inform themselves about the facts of their client's cases and the applicable law and determine that they can make good faith arguments in support of their client's position. So we're driven on precedent, but you can make an argument for modification, revision, or extension of precedent, or even overturning precedent if there's a good faith basis. This rule recognizes that there'll be discovery, there'll be some legal research, there'll be some other things to make sure that you can make this good faith argument. So it's not about winning or losing, it's about whether or not you can make a good faith argument. We did 3.1, and then we talked a little bit about civil procedure rule 11 in the text. And we noted that if we're talking about rule 11, we're talking about sanctions that a judge can impose, and there's a safe harbor provision in rule 11. You can have monetary sanctions for frivolous claims. 3.1 deals basically with bar disciplinary claims. There's no safe harbor in 3.1, but it's extraordinarily rare for an attorney to be sanctioned if they withdraw something that they think is maybe frivolous. So that's what the text said. And then from there, we went to the Paula Jones case. It was not really clear. This is problem 11.1 on page 682. It wasn't really clear what a reasonable lawyer would do to check out Jones' story. We had a problem of a security guard on the governor's detail. That's a problem because he may tell the governor. So we talked about trying to locate and discuss this with other factual witnesses. We also talked about maybe a documentary trail giving us the right way to go in terms of the evidence. There's no real clear answer to that. And then we went to candor towards the tribunal. On page 43, you have a chart. And that tells us a number of different things. We cannot present false testimony or a false statement of fact to the tribunal, of course. We have to disclose authority in a controlling jurisdiction, even if it goes against us, if the opposing counsel has not disclosed it. We cannot offer evidence that we know is false. Now, that doesn't give you any leeway in terms of acting like you don't know something. Knowledge can be inferred from the circumstances. And then there is this duty to reasonably repair, make remedial measures. And it's sort of an exception to 1.6, because one of the things that you can do, if you talk to your client first, as we emphasized in our last class, and the client is still unwilling, you have to say, I have a duty to report this as officer of a court. So this is something that we started off with at the very beginning of the course, looking at all of the rights and obligations that we have as attorneys. And this is an instance where it's really conflicting. This is why it comes after the conflict chapters. This is an example where our duties as officers of the court may conflict with our clients. Then the duties continue to the end of the proceeding. And notice this, even if compliance requires disclosure of information otherwise protected by 1.6. So the major point in Rule 3.3 is that a lawyer cannot allow the tribunal to be misled. On any level. Controlling authority, false testimony, your client presents something that's false, or you make a false statement, has to be corrected. Reasonable remedial measures, up to and including disclosure under 1.6. So 1.6 does not insulate bad conduct. And then from there we went to Nix versus Whiteside on page 47. There is no constitutional right to present perjury. So this attorney, you see at the bottom of page 87, did not breach his duty to the client, did not undermine the client's Sixth Amendment right of confrontation, because there is no duty to present perjured testimony. And so now we start this problem 49. I think I set it up. This is the first component, flight from Sudan, scene 1. Again, a real case, and we are trying to figure out what to do here. So we represent someone who wants political asylum. Our major thing is that we have to find that there would be danger to our client if they were deported. And we are going about trying to make that factual determination. We have to meet the standard at the deportation hearing of a well-founded fear of persecution, repression, oppression. And we have some information, some good factual information. Our client was involved in some protests, but we're trying to substantiate whether or not our client worked for a newspaper. And we have sort of slight factual information, but nothing to corroborate it. And this whole problem is driven by corroboration. Only a third of these applications are approved, you see on page 490. And so corroboration is going to be key. So it's easy for us to corroborate the context, but we still have to answer the question, did our client, Vera Gabi, ever work for the newspaper? We intend to file an affidavit tomorrow, and so we're trying to locate someone who can substantiate these claims. And now we're at a point where we have contacted somebody who's the editor of the paper, Hamad El Parah, and he says he does not recognize our client. I know everyone who works for this paper, your client does not work here, and now we have to resolve these 5 questions on page 491. So, what do we do? Should we tell our client, Vera Gabi, about our conversation with Mr. El Parah, the editor of the newspaper? Yes?
Well, I think you sort of have to tell the client about the conversation. That's an obligation for you.
Okay. And why do you say obligation? How do you know about that?
because you're trying to substantiate what your client is saying, and if you're not finding any information that can substantiate, you have to tell your client that.
Okay.
That's keeping them informed how the case is going.
Okay, and so this is question one. So you're saying apart from what we're trying to do substantiate this is just the lawyering. We have to talk to the client. And you and so we covered this rule. 1.4. So yes, we have to talk to them. Not only to substantiate anything that we might have, but this is going to help us assess almost how much we can believe our client. So if you look at 1.4, keep the client reasonably informed about the status of the matter. That's that. So we did some of that before. And then comment 3 says a lawyer is required to talk to the client in order to accomplish the client's objectives. That's what we're trying to do. So we do that. So now, but we still have some problems. We have to talk to our client. The second question is, should we file the affidavit? Should we file the affidavit? Well, one way to look at it is, do we have enough to file the affidavit? We have enough. What do you do? So do you turn on your client? Oh, I think you're lying. I can't confirm this. What do you do? Let's see. File the affidavit? Yeah, Ms. Paul. Should we file the affidavit? Take a guess, because this is you almost have to take a guess really the way this is set up, because we don't really have anything. We have your client telling you that he works at democracy.
I think I would hold off on it if there's a possibility of extending.
Okay.
And
Very good. And so notice this. If you look in Rule 3.3, we know that we can't present false testimony. We certainly want to avoid that, so we want to make sure we can substantiate that. So should we file the affidavit? Probably not now. Probably not now. And we can look at Rule 3.3 to give us guidance. You don't have to remember the rule numbers and everything for the exam or for the MPR. I'm just doing it so you go and look at the rule. So Rule 3.3. And you'll see when we get to the second part of this problem why this is important. So 3.3, comment 8 says, notice this, the lawyer must know that this testimony is false. So the prohibition against offering false evidence only applies if the lawyer knows that the evidence is false. We don't know if the evidence is false. We're trying to corroborate this. So we hold off on giving the affidavit. A lawyer's reasonable belief that evidence is false does not preclude its presentation to the trier of fact. Have to know. A lawyer's knowledge that evidence is false, however, can be inferred from the circumstances. So we're not even there yet. And notice this last sentence too. Thus, although a lawyer should resolve doubts about the veracity of testimony or other evidence in favor of the client, the lawyer cannot ignore an obvious falsehood. We're not there yet. So at this point in time, we can resolve doubts in favor of our client and keep investigating. We want corroboration. So that's good. We're still in the preliminary stages. We're having this conversation. We are still investigating. The third question says, should you ask the court for permission to withdraw? So this is trying to get you to say, well, at this point in time, I can't corroborate anything, so maybe my client is lying, so maybe I should get away from this. What about this? Should we withdraw? Yeah, talk. Go ahead.
I don't think you should, not this way, because you have one person saying, well, I don't remember more.
A little bit louder. You said no?
I say no.
Okay, tell me why.
Because, yeah, right now you can't corroborate anything, but you won't be able to find one other person who works at the paper. Just because one person doesn't remember him doesn't mean that somebody else won't either.
Okay. Okay. So it's too soon. I mean, and notice what we've been doing with this rule. The rules balance two things: your representation and advocacy for the client, but we have this strong bright line prohibition against us presenting false evidence or making false representations to the court. So it's too early to withdraw. Now, this is a good review of Rule 1.6. I'll just paraphrase this. Was Rule 1.6 violated? By contacting El Parra, discussing Baragabi's case without first obtaining Baragabi's consent. Or is this a strong prohibition against this type of evidence? What do you think? Yeah, go ahead.
I say no.
Okay.
Because he gave him a point of consent to try to figure out, to corroborate the story.
That's good.
And if an attorney had to stop every day and ask at every moment of their work whether they could do something, it would just be
That's good.
too much.
Very good. Compliantly authorized to carry out the representation. And you know, you think about it, this is the only way we can find out if we ask these questions about where he was employed. He wants us to corroborate this, and so this is the way to do it. Those numbers correspond to the question. I'm just paraphrasing the question. So Baragabi gave permission to corroborate, and 1.6 sort of tells us that that is part of the rule. Even 1.6a, the disclosure is impliedly authorized in order to carry out the representation. And so that tracks nicely with the rule. Now finally, one last question on part one. Did we make a mistake by doing our job too well? After learning that the editor, El Parra, was in Canada, should we have said to the Beragabi, I found a number for the editor in Canada. Of course, I want to call him only if he will corroborate your story. Should I call El Parra? Is it okay to avoid learning all the facts? So I guess he would say, our client would say to us, yeah, go ahead and call him. That'd be a good sign to us that maybe everything's truthful. Or he says, no, I don't think you should, and then we avoid knowing everything. Did we do our job too well? What about that? Do lawyers, should they strive to be a little bit consciously ignorant in some cases, and this is one of them, or what? I think you have to sort of ask these questions, and you can't sort of know too much. This is it's important, and it's probably the only way that we can corroborate, because we need those witnesses. The only thing we have now is, yeah, he participated in some protests, and the government can say, well, yeah, everybody does that. He hasn't shown a well-founded fear of oppression. He hasn't shown that he's like a leader of these protests. The government has targeted him, any of those things. So we have to ask these questions, and that's the balance in terms of moving towards corroboration. So we still are drifting a little bit, and then if you look at the top of page 495, you have the setup for question 2, part 2 of this. So you see this big paragraph? So we've been talking about the prohibition against lawyers presenting false testimony, and even earlier in the class we said a lawyer cannot participate in fraudulent conduct when we did the Reese's Pieces problem. And this first big paragraph on 495 talks about that. But there is something missing in these rules. I mean, it seems like the rules are talking about those blatant lies or those blatant falsehoods or those fraudulent things that just jump off the page. But we know in real life things are more nuanced, more gray. What about partial half-truths? The rule really doesn't deal with that. And so that's what the text is saying. The authors even goes for us to say that they did a Lexis search of about 200 bar disciplinary cases and plugged in the word deceit or omission together with Rule 3.3 candor and 8.4 misconduct. And all of those cases nearly involve deceptive conduct by lawyers outside the context of litigation before tribunals. Tax fraud, embezzlement, those type of things. None of the cases resulted in discipline of a lawyer because the lawyer or witness called by the lawyer misled a tribunal or opposing lawyer without actually making a false statement of fact. So this is the kicker that sort of sets up the second problem. What about these partial half-truths? Even if lawyers never or are rarely disciplined or sanctioned for the half-truths of the testifying clients or witnesses, what should lawyers do when their clients appear to engage in non-perjurous deceptive behavior? So not quite perjury, but it's sort of a misrepresentation, a lukewarm misrepresentation. Is there a duty to disclose that half-truth? And so that's what problem 11.3 does, scene 2. So we get here by, we sort of answered all these questions, and we made the decision, I think appropriately so, to resolve doubts in favor of our client. So we're not calling our client a liar or anything. We are doing the work to make sure that we corroborate the story. We still have to file the affidavit. And so we resolved doubts in favor of our client, and now we're at this hearing, and we have a witness. So we still have this nagging question, who does he really work for? We need corroborating evidence of the political demonstration. And we have Farak Massara. He is our witness. A good factual witness, but a witness nevertheless with some problems. Credibility problems. No one's perfect. So his major thing on page 496 is, this is the only person that we have who can corroborate our story. So this is going to be very important. We need him to meet the standard of well-founded fear, and we need him so that we can be successful at this deportation here. So he had been a dissident leader in Sudan, and he is another refugee whom Beragabi met after he came to the United States, and he has some problems getting political asylum. He had been a dissident leader. The government's interviewer provisionally recommended that he be granted asylum, and then there was something about an outstanding warrant in Pennsylvania from Massara. The government then asked him to supply a certificate from Pennsylvania. Your paperwork will be okay, but the government nevertheless withdrew the provisional recommendation of asylum from Massara. So he was almost there, but then we find something in his record. They say, okay, this is conditional to some documentation. The government nevertheless decides to withdraw the provisional recommendation of asylum from Massara. So we have him testifying at the hearing. Put Massara on the stand, our only witness to corroborate, and he testifies to Beragabi, and he participated in 3 demonstrations outside of the Sudanese embassy in Washington, D.C. Now, look at this cross-examination. So we want him, this is our witness, and we want him to say all these good things to show that our client was involved in political activity, and if he's deported, he has a well-founded fear of repression, imprisonment, maybe even death. And this is the guy to do it. So what about this cross-examination? What is your immigration status, Mr. Massara? I was provisionally recommended for asylum. And this is the truth, that's the truth. But there was something wrong with my fingerprints, that's the truth. And I had to get some records from the police in Pennsylvania showing that I had not been convicted of any crimes there. That's the truth. I got those records and supplied them to the immigration officials. Look at the next question by the government. Anything wrong with that question? If you were a government lawyer, would you go right into that, or what? What do you think? So our witness's response is, and this is cross-examination of our witness, I got those records and supplied them to the immigration officials. And the next question is, how many people attended the rally in which you and Mr. Beragabi participated? Anything wrong with that question? Should the government officer have done more? Maybe not. Look at this. So the government officer asked more questions. This is the key at the bottom, page 496. Asked more questions about the demonstration, but never returned to the subject of Musara's immigration status. Musara never stated that he himself was still a respondent in deportation proceedings. So the only answer that's on the record is I got those records and supplied them to immigration officials. That is the truth. That's not a misrepresentation. So the top of page 497 says this. Should you take steps? So this is getting at reasonable remedial action. Should you take steps, including our own disclosure if necessary, to inform the government or the court that immigration officials withdrew the provisional recommendation that Musara be given asylum and instead had put Musara back into deportation procedure? We say, hey, wait a minute, our witness in this deportation hearing didn't give the full story. I want to put this on the record that he has was provisionally approved and now this has been withdrawn, just to make the record accurate. Did you do that? Is this false and misleading? Is it fraudulent? Do we need to take reasonable remedial action? Yes, go ahead. Thank you. Very good.
I don't think you would need to tell them
Okay.
because he's not lying. It's really not that misleading. He's like all of them are facts. He just didn't say the last part. So it's really the government's attorney who messed up because he should have followed up by saying, "Hey, what's your current status?" He didn't even really answer the question. So I don't think you should do anything. It goes against what you're representing your client. It goes directly against your client.
That's good. So you just be, that's very good. So, and also if you plug it into the rule, we haven't really done anything. We haven't knowingly presented evidence that we know to be false. We haven't come to know of this falsity. This is something that was left out because of the government failing to ask that question. I mean, the next obvious question is, after you submitted these papers, what is the status of what is your immigration status now? Has your immigration status changed since you submitted those papers? Doesn't ask those questions. So, in comment 10 of 3.3 talks about taking those reasonable steps, but it has to be when we know that we've offered evidence that was true, and we subsequently find out that the evidence is false. Everything that this witness said is true. But what is left out is the status, and the government should have asked that question. Ms. Harper, go ahead.
I was going to follow on what she said. I mean, technically what he said is not false. He gave the facts that he gave what happened. The only like lie, I guess you could say there is a lie omission where he just omits the last part of that events, which the government didn't ask. He never asked that last part. So
But you know what? In some ways, yeah, that's a little murky line. But on some level, it's not really even an omission. He just gave the facts up to that point, and it's really up to the government to say, well, that's the key question. What is the status of your immigration? And the government doesn't follow up. It goes immediately to establishing well-founded fear without trying to discredit the witness's credibility by saying, oh, you're not even provisionally approved anymore based upon these papers. They should ask that question. Let's do this drug test. That's interesting. Now, before that, on page 499, there was a major controversy. Show how old I am. You probably don't even remember O.J. Simpson trial. Anyway, on page 499, you've heard about it on the internet, right? Anyway, so a major part of that case was race, of course. And so there was this controversy about the defense attorneys going to O.J. Simpson's home and restaging it. I mean, it's always a kind of a bad idea to take the jury to the scene or to find these different scenes. And Judge Ito did that, and I think that sort of, the trial sort of got away from him once he did that. But you have the sort of restaging of this O.J. Simpson's house, and then the news article on page 499 talks about manipulation, what this did in terms of the jury. And so also how race was useful, because O.J. Simpson really didn't have strong connection to the African American community, some would argue, until this trial. And so the defense attorney took from his office a Norman Rockwell print of a girl being escorted to the school by federal marshals. You've seen that famous photograph, a painting by Norman Rockwell during the time of Brown versus Board of Education. And so this was designed, the argument goes to manipulate public opinion and solidify support from the African American community, which O.J. Simpson was basically detached from. So that was a big discussion, but it goes into truth and falsity in litigation. What are you showing and what is being believed? So that flows nicely to this next problem, the drug test. The drug test. Look at on page 500. So this is interesting. You could actually be in a situation like this. So this is dealing with the presentation of evidence, and now we're moving into 3.3 and 3.4. I think this is a better example of literal truth on that. So we have this situation where in order to corroborate our claim, we have to present evidence. And this is 11 for the drug test. Page 500. And so we represent Frederick Kerr's divorce action, and his wife claims that our client uses methamphetamine. Judge may suspend visitation rights of a parent who illegally uses drugs. So we have to get a drug test in order to corroborate our contention that our client is clean and should be entitled to full parental rights. So we advise our client to get a drug test to prove that he is not using methamphetamines. And then our client goes to the town's hospital, asks them to do a test for methamphetamine. Send a report to us as the attorney. The lab telephones us and reports that Frederick tested negative for methamphetamines. That's good news. That's great. That proves our claim. However, the test screens for 8 substances, and Frederick tested positive for marijuana. She faxed us a copy of this printout. So then we look at, this is good and bad, right? We have no methamphetamine, but we have marijuana. It's still illegal drugs in this jurisdiction. So we say, get a new test only for methamphetamines only, but she says, I can only do multi-level drug screening. She says she can only do multi-substance screening. But she could provide us with a second report omitting the marijuana results. We say, do it. And she does. She mails us a part of the original printout, and comparing the old report that she mailed us and this new printout, we see that she simply used scissors, cut off the bottom portion of the original report, and sends us only the top portion showing that the client tested negative for methamphetamine. And we have these questions. All these questions sort of lead up to, should we have submitted this document? And this is interesting. So what about this first question? When we get the call from the laboratory, would it have been proper for us to say, thank you for this, get rid of the, dispense with the written report, advise further to go to a new testing facility, and make sure that that laboratory does not do multi-level substance testing, that it just can test for methamphetamines and not for any other substance? Could you do that? Can you do that? Tell your client, go somewhere else and get another report that only tests for methamphetamine. Can you do that? So think about it, that isn't, you're just trying to figure out what can you present to the court, because remember candor, and remember fairness to opposing counsel. Go ahead, Mr. Brown.
I'd say yeah,
Okay.
to do that.
Yeah.
Have to incriminate himself with marijuana.
Yeah, yeah. That's it, yeah. You haven't done anything, and so you just keep that. Maybe even throw it away, because there might be some discovery. That's not concealing anything. You're just going and saying get another test, but you certainly don't want to be in a position of presenting this to the court because that document has been altered. And we're going to see what happens in the real case. So I think you certainly can do that. That's probably the better approach. And that would have solved all these problems. Okay, we're going to do it again. And even if you kept it and there was some discovery, you could say, well, we tested for what we were litigating about, and that was her allegations that he used methamphetamine. He did not use meth. And so moving on. Go ahead.
I still like to that because he did not use meth, but as well, you still have outward knowledge because the knowledge of the first report is still going to be there with the lawyer. So it still feels almost like you are withholding like important information from the court.
Well, no, because you haven't represented that you have anything other than what you're going to present to the court. And if you did do that, as Mr. Manley suggested, you may be turning on your client. We really don't have to do that. We can respond. It's like responding to a document request. Exactly like responding. If they ask for it, give it to them. But if they don't give it to them. So we're litigating about meth. I'm giving you a test about meth. Now, if they ask me the question, do I know of anything else? I mean, and I'm asked that in open court. I can't lie. So yeah, but we're testing for methamphetamines, and he's negative for that, and he's a fit parent, and on from there. But these rules require balance because we don't want to view our role as officers of the court so expansively and formulaically that we destroy our client. And that's what we've been talking about these examples. So that's good. So now we're moving closer and closer to what happened. Now that we have received the partial report in the mail, would it be ethically proper for you to send a copy of it to Mrs. Curse's lawyer and then offer it as an exhibit that would be part of the evidence? So this says, this is sort of a variation of us simply responding to a document request. Here we're taking the partially altered document, giving it to opposing counsel, and saying we are going to offer this as an exhibit in court. Can we do that? Can we do that? Does 3.4 tell us anything? Yeah. So we'll be submitting this partially altered document. Would that be a form of presenting false evidence? Yes.
I don't think it would be false evidence, but it says that you have to allow the other party access to documents that are potential evidentiary value. So I feel like you should give them the full document, and then they can maybe amend their thing to say any illegal drugs, and then kind of go forward from there. I feel like it's risky to give them an altered document.
Oh yeah, it is.
Altered,
Oh,
and then get in
definitely.
trouble.
Definitely. It's risky to give them the whole thing too. Yeah, so I think your point sort of proves that this is really bad because there's only two ways out. You can give them everything, not hurt your client, because then we say there's more negative information that can be used against our client. But not only is our client okay with methamphetamine, but uses other drugs, that opens up a whole new thing. So if we give the full document, that's going to open up more questions and hurt our client. If we give a partial document, we're not giving them the whole thing, so we're representing that this is all there is, and that's false. And even if you say that, well, that's debatable, you are still obstructing access for the opposing party's ability to assess all of the evidence, like you pointed out. So a number of different problems. This altered document could not be entered into evidence. So that's why problem one is, question one is good. You solve this entire problem by getting a new test that tests only for methamphetamine. Now, this is the bad part. This is what actually happened in the case. So we make the decision, we're going to enter this into evidence. So when we do enter this into evidence, the judge then asked us, as he did in the real case, is this the entire report? So a lot of you, this is the entire report. This is what I have. So, and it has 4 ways to answer this. Is this the entire report? Yes, Your Honor. So that was outright. That's just an outright lie, right? Yeah. Now B is what the lawyer said. That's what I have, Judge. That's what I asked them to screen for. So that's that. And then Letter C, no, Your Honor, tested positive for marijuana, but I asked the lab technician to exclude that result from the report since Mrs. Kurtz accused Mr. Kurtz only of using methamphetamines. That was our discussion about giving the entire report, disclosing everything, but that hurts the client. Actually, Your Honor, I've just decided to withdraw the exhibit. Now that's interesting. What about that? Yeah, Ms. Matt.
I feel like D is almost bad C.
Sure it is. Tell me why.
Because it just throws a red flag and then gives that
You said why?
the entire report
Yeah.
and you're getting told for not producing it.
Yeah, that's good. Ms. Harper, go ahead.
This is a catch-22. I feel that no matter which option you choose, you're still gonna face discipline for something or another.
Yeah, well, yeah, the best option is not to introduce this. This is what it's getting at. So yeah, I think you're absolutely right. So what do you think happened to the attorney? The attorney did submit this, and he said letter B. That's what I have. That's what I asked him to test for. And that's true.
Is it true?
That's what it is. That's what I tested for.
He tests for everybody.
Because, yeah, but you originally were
At this time, this is what go ahead.
At that time. But technically that's not true either because before you had more of that report.
Mhm.
And then you asked for it to be altered.
Mhm.
So technically, that's not what you have. You actually had more.
Mhm.
And so you're still lying.
Mhm.
So
That's good.
that's not gonna work. It's going to say you've been lying to the
That's
tribunal.
good. That's good. So what do you think happened? I think you're right. What kind of punishment do you think you got? Not real bad, but still bad.
And you have all the reprimands.
That's right. Public censor intentionally evaded the plain and understandable questions of the judge. So you see how much problem we had sort of playing around with being partial, this is what I have and all that. The court was like, look, you knew what I was asking and you evaded that truth, so that's a violation. Violated the duty of candor, violated the duty to opposing counsel, general misconduct, because you know under 8.4 you cannot give a false statement either. You cannot engage in dishonest conduct. And so all of that. And so that attorney received a public censor. Oh, I forgot to say one thing. The deportation case. Back to the second scene. What do you think happened? I didn't say what happened. The flight from Sudan. What do you think happened? We said, I didn't tell you what happened in real life. We all concluded that no, we shouldn't do that. The government should have asked the other question, and they didn't. And that was the right answer. But I want to tell you what happened in the real. What do you think happened in the real case? So this was a clinic case, and the students didn't correct the record. And I guess after the recess, or maybe a day or so later, the government said, "Oh, I forgot. I should ask that question." And during recess, the day before, the lawyer says, "Why didn't you introduce into evidence a copy of the official document showing that your witness was granted asylum?" One student didn't answer, and the other student said, "That's confidential," and they just walked away. So the government lawyer didn't follow up, and then he later on checks, this is like a couple days later, and finds that Massara was currently the subject of deportation hearings. At that point, the government tries to reopen the case, but that motion was denied. It said that the ultimate ruling about deportation or not was not based upon Massara's testimony. So the government moved to reopen the case on the ground that Massara had misled the court. And argued that the legal clinic had an affirmative duty that it violated by offering this misleading testimony, and the judge rejected that and said that he was not relying totally on Massara's testimony. So at that point, the case moves on. The original attorneys don't have to submit an affidavit, and ultimately that attorney was discharged, the original one, before filing the affidavit, which may have had some falsities in it. There was new substituted counsel, and the substituted counsel only asked for all of the documents filed in the case, not the affidavit, and ultimately Baragabi got political asylum. So that's another sort of real-life example of how things worked out. So back to this. What about, look at the top of page 506. So, and we sort of did this in our problem. A lawyer cannot unlawfully obstruct another party's access to evidence, or unlawfully alter, destroy, or conceal a document. So that was that scenario that we had. That if we presented that to opposing counsel in the drug test problem, we would have been presenting an altered document. So it's best just to get the test only for methamphetamines, and that is the document that we're presenting. So we can't unlawfully obstruct access to evidence. So let me sort of set this up, and then we'll look at on page 508. You have several different scenarios about whether or not a lawyer should disclose evidence. And Orwell is one. Emory Ryder is another. People be Merida. Another. And Morel. Now, so when we come back, we're going to look at those propositions, but we're going to look at this case, a child pornography case. And in that case, we had a counsel who had access to this information. And then the question is, should the attorney deliver this information? What would that mean for the client? That's on page 514. But let me sort of go through what these cases stand for. You have a good summary of all of these cases on page 513. These bullet points. And so those bullet points represent, I'll just put the cases on the board so you look at them briefly. Those bullet points represent a summary of the cases, and you have these major propositions, and we're going to use that to analyze this case. So the first bullet point on the top of page 513 says, an attorney must not disturb or move evidence. So the client tells the lawyer about where evidence is, the lawyer may not move or disturb that evidence. That doesn't mean the lawyer cannot inspect it. The lawyer certainly can inspect the evidence, but cannot move or conceal it. Because notice that would be a violation of 3.4. You're altering access to a document. Another line of cases, it says that a lawyer merely inspects the evidence without disturbing it. The lawyer's knowledge of its location remains privileged. So in one of the cases, the lawyer moved the evidence, had an investigator look at it, then moved, so the privilege was lost because that evidentiary site was disturbed. In some states, the lawyer can take temporary possession of physical evidence, but cannot alter or destroy that. And some laws even go as far as requiring the lawyer to turn over the evidence to the police or prosecuting attorney. Now, this brings up some interesting questions about whether or not the attorney's duty as officer of the court actually undermines the 5th and 6th Amendment. That's what you have in the 4th bullet point. If a client delivers physical evidence of a crime to a lawyer, the lawyer may examine and test the evidence, but must turn it over to law enforcement. So the client says, yes, I did it, here it is. You examine it, then turn it over. Then the question is that a violation of the 5th or 6th Amendment? That applies to real evidence, of course, and documentary evidence as well. And then finally it says, even if you do derive the source, some effort should be made to preserve the lawyer's identity, as that can undermine attorney-client privilege and any other privileges. So we're going to review that, and then we're going to start on problem 514 when we come back on Tuesday. Have a good weekend.